that I try to make in the petition is that the Board of Pharmacy must annually review every substance on the controlled substance list to see if its skill is properly scheduled. And it's my understanding that in a review process that there will be multiple findings that the Board of Pharmacy comes about. And there's also another statute that says that the Board of Pharmacy shall place any substance that they find, and I think that word find is important, just because of the fact that there is a review process where there are findings. Anything that they find to have no accepted medical use to be, or specifically in the United States, to be a Schedule I substance. And the main evidence that I'd like to present forward, and I have in the petition, is the 15 state laws that say that marijuana does have medical value. I mean, there are a large amount of different points that I try to make in the petition, and there's a lot of topics that you guys might have on your mind. But that's really the crux of my argument, is that marijuana cannot stay in Schedule I. That it can be moved elsewhere or completely deleted with the power given to the board by the state legislature. Yeah, I guess I'll just leave it at that and answer any questions that you have.
David.
Are there some
forward.
or staff would you like to?
Well, actually,
What? Oh yes, I'm sorry. Would you
No.
like to make a statement?
Well, I don't have a lot there. And I think Kurt's petition was very thorough and covered most of the points. As I understand it, the state legislature, has empowered the board with the ability to remove marijuana from Schedule I. And I just hope, I realize that it is a contentious issue. I realize that there's things on both sides, but I wish we could not get politics involved here and just look at it on its scientific merits. I mean, it is pretty clear that marijuana has medicinal value. It's pretty hard to argue that. And so if it does, why would we deny people that need it? I mean, we have a Facebook page, and as I was leaving to this hearing this morning, I was looking at one of the members on the Facebook page that said, we mentioned that we were going to the Board of Pharmacy, and they said, oh, that would be so good if it got approved in Minnesota. I could move back to Minnesota. I mean, so we literally have Minnesotans that go to other states because they can't get access to their medicine here. And so let the legislature fight out, and the federal and so on, whoever, and who overrules who. But I wish you could, I wish the board, I respectfully wish the board would take it on its merits itself and at least recognize that it does have medicinal value. That's all I have to say.
And one thing I'd like to add is that this does not result in immediate access, in my understanding of the law, for anyone. It's simply the first step in the process of reforming the scheduling, both in the state level and also federally as well.
Is there anybody else in the general public today that would like to say something? You can keep your comments fairly brief. And please identify yourself and turn your microphone on the red line.
we might ask this. How
Go ahead.
many other people might want to come up and say something? Then you can make your comments a little bit. Then you can make your comments a little bit longer. It's just if everyone wanted to talk.
No?
That's fine.
Hi, my name is Melissa Blossom, FOSSUM. I too am a pharmacist. I got my pharmacy in 2001.
Where do you work currently?
I work at Olsen Brothers, the community pharmacy in Medina. So what I just want to say to the board, this is an issue that is going to be coming up again and again in the future. The younger generation passing legalization. I know that there's the federal, the federal discrepancy, the state discrepancy. Marijuana is one of the most studied medicines, as we all know. Its benefits have not been realized. Why is it the most studied medicine when its benefits have not been realized? Why is it, we just ask ourselves as pharmacists, why is there a debate about it? Why is this such a hot topic? And just to tell the Board of Pharmacy, just to say in our minds, what benefit does it have? And why are these legal ramifications coming up? And these are all just questions. And this is the second petition that is being brought to the Board of Pharmacy. The example in Iowa, I'm sure that there is going to be more legal procession concerning this topic. So just basically, I just want to ask all of you, as professionals, as pharmacists, as
Well, what would you say as a professional, as one of us being a pharmacist, what would your thoughts be? That's what we're really interested in hearing. So what would your thoughts be on why it should be considered by a board?
because it is a plant. It is a medicine. We have 75% of the drugs on our shelves derived from a plant. This plant has medicinal use. It's been proven over and over again, but it's in a Schedule 1.
You said 75% of our drugs come from plants?
On a shelf, absolutely. You don't believe that, like a derivative of a plant?
Just a question, as a pharmacist yourself, are you aware of any double-blinded placebo-controlled studies that show that smoked marijuana is effective for any particular disorder?
Absolutely.
I don't do.
I don't know.
I'm gonna have to research that.
There
I
are.
haven't researched that at this point either, because actually before we even get to what's sort of the core, what I would define as the core issue that I think petitioners want us to address, which is whether or not this has accepted medical use. And I know this is a dissatisfying answer to individuals. The board has a Facebook page, and there have been comments that I've allowed to remain up because I think it's important for the board to solicit input from the public, and that's one of the ways we do it. And I know there's some frustration because I've responded to some of those comments about some of the legal considerations that the board has to look at, I think, before we get to that core issue, including some issues with the way some provisions in Chapter 152.02, that section, which was written actually many years ago, some of the contradictions within the chapter. But at any rate, that was just a question for you. I mean, one of the things, just when it talks about accepting, if the board were to get to the point, did a review, and try to determine what accepted medical use meant, which is not defined by the legislature. There are a number of different ways that can be done, and that actually would require some research as well, both pharmacological and clinical research and legal research, because we can't just necessarily, there are certain ways when the legislature has to define a phrase or a word, and we as the agency are responsible for enforcing that particular chapter or section. There's certain ways that you have to go about trying to determine what the legislature meant by that phrase. Okay. So there are other issues we have to look at. One issue that we would have to get to at some point is, what accepted medical use is.
So let me just add, I did find there are many studies of the effectiveness of smoked cannabis. And so I'm looking at a report here right now. It's the effect of cannabis on neuropathic pain and HIV-related peripheral neuropathy. I'm not a doctor. Done by Donald Abrams. It says the primary objective of the study was to evaluate the efficacy of smoked cannabis when used as an analgesic in persons with neuropathic pain from HIV associated. In the double-blind, randomized, 5-day clinical trial, patients received either smoke and so anyway. But I could go on. I have at least 6 of them right in front of me. I think
How many were involved in that study?
this one was. Say right here. I'm sorry.
And there actually was a National Board of Pharmacy Association meeting in Anaheim where I believe that this specific individual spoke at, Donald Abrams. I think the title of the speak that or the talk that he gave was "Is marijuana a miracle claim to miracle cure?" or something of that sort. But I do want to articulate as well that the petition itself is specifically asking that this determination be made because of law. It is not science. The specifics are that our current state law says that Schedule I substances are defined as having no accepted medical use in the United States. And the fact of the matter is that there's 15 state laws that say marijuana is medicine. Those 15 states are in the United States. So therefore, simply by a matter of law, the word marijuana ought to be stricken from the Schedule I paragraph. And any sort of science can then come as a result of some sort of study, perhaps done by board staff, since there's no longer a council on controlled substances, or I forget the exact term.
Advisory council.
Advisory.
The legislature legislated out of existence in the mid-1990s, but unfortunately they didn't remove all the references to it.
But the point is that the science is something that comes after the response to my petition, which is simply arguing that the law itself needs to be followed. Marijuana specifically, law enforcement is a big fan of using it as a tool to arrest people and incarcerate them for their breaking of the law. And I simply would like the board to follow the law as well, and I'll try to be the law enforcer.
Go ahead. Go ahead.
Actually, this is one thing we might agree on today.
Sure.
Is that the law comes first.
Yes.
We may have a difference in the
Yes.
interpretation on what that law requires the board to do.
Agreed.
And there are some sections of law I don't think that in your petition that you looked at, which I'll get into.
Sure.
But on that we agree. I mean, I think the basic issue before the board first is what the board can do pursuant to the relevant laws, what the board is required to do by the relevant laws, and what some issues might be just from a legal sense before we even get into the possibility of actually engaging in the rulemaking process. Ultimately, this is a petition to engage in the rulemaking process to remove marijuana from Schedule I. Which Mr. Hanna and Mr. Engelman were allowed to do under Chapter 14. So the very specific question here for the board really isn't does marijuana have accepted medical use or not per se. It's do we engage in the rulemaking process. Now, whether or not marijuana has accepted medical use might come into the analysis about whether or not to engage in the rulemaking process, but there are some other questions also that come into play as well. So,
Okay.
go ahead.
And if the board would like, I really would like to hear both issues to be brought up, or responses to both of those issues to be brought up. Both if the board has the ability to do this, and also if marijuana does have accepted medical use in the United States, or if it does not. Those are two different issues I'd like to be answered.
Well, what I was just going to say is, I understand what Dr. Weiber's talking about today, the specific issue under consideration. As part of the process, I, as a pharmacist, would not be able to divorce myself from the science as part of the whole package when considering whether or not to move it from Schedule 1 to any other schedule or lack thereof. And I would probably say that a lot of my colleagues here would echo my thoughts on that. I mean, we would have to, in order to even consider doing that, we would, as part of the whole consideration, we would have to look at whether or not there is proven, efficacy. And I don't know that any of us would be able to answer that question today without doing further research.
I would like to alert the board to the fact that the Iowa Board of Pharmacy made the exact same declaration to this same petition in 2009, and that was actually taken to court. There was a judicial review of the agency's action, and the judge did remand the decision back to the Board of Pharmacy, saying that this is not an issue of science, that the board does have legal duties that they must look at. And like Cody did mention, law does trump science in this situation.
Well, he didn't exactly say that, but Dr. Weiberg does have some
Legal
comments.
considerations have to come into play.
Right.
There are some legal considerations that the board has to consider, I think, before it gets to the point of considering the scientific considerations. Because if, I'll just put it out there, if, as I believe, and as I've included in the staff analysis, it, notwithstanding, well, actually, first of all, there's some disagreement, I think, between the board and you as to whether or not this is a requirement, whether the board is truly required to do this. That's one legal issue. There are other legal issues because this is a specific petition about the rulemaking process that the board has to consider, that I'll get into in a minute. But I think actually before I get into some of that, there's at least one other gentleman that wanted to speak. Sure. And I do think we want anyone from the public who wants to speak.
All right, would you like to step up, please, and state your name and your affiliation, company, and spell your last name? Thank you.
My name is Maxim Chouet, last name Chouray. I was
first name?
MAKSIM.
And are you affiliated with any organization or just you're speaking?
I'm a member of Normal, but I'm just
Okay.
speaking
Okay.
on behalf of the citizens of Minnesota. I would like to highlight that Marinol is currently legal. It's legal prescription. You can purchase it at Target, in any pharmaceutical company. Marinol, namely assessment, has caused numerous deaths, which is proven already. While organic cannabis has not caused any. There has been no scientific evidence that has shown that. I believe that you guys should remove cannabis from Schedule 1. You guys are doing the people of Minnesota a great thing, and this is just the first step to do something right. A lot of people are hurting because they don't have access to cannabis. You guys don't have to give people the access to that. Let the law basically play itself out. I hope I'm not going off topic here, but do the right thing. That's what I'm trying to say. Don't, just.
I have something to add to that. I wanted to ask the board, so with cannabis derivatives being potentially approved by drug companies, where would that sit in a schedule? If you took a derivative, constituent of cannabis sativa, marketed it, chemically synthesized it, where would that fit in and what would the board decision be?
I was distracted. Do you want to repeat this question?
Okay, so cannabis sativa is very researched by the drug companies right now, as we all know as pharmacists. They are taking, a constituent, a derivative, and chemically synthesizing it, like the Marinol. Where would that fit in a schedule?
It's currently in Schedule 3. It's Provenol.
At one point it was Schedule 2, now it's Schedule 3. The difference, of course, being, and that's actually one of the things that I've noted in Mr. Hanna's memorandum. I've actually written some notes I'll go through actually about some they're making some memorandum. So I'll address that issue, actually.
What I'm saying is that there's further drugs in the pipeline that are coming out, not just the Marinol that's already out.
If those drugs do get to the point of eventually getting to the market, you know, as a pharmacist, they will have gone through extensive clinical, trials, double-blinded trials, and will have been compared to whatever the current standard is, et cetera, to show benefit or superior efficacy and safety.
Marinol underwent the process, the IND process required of the Drug and Cosmetic Act to be approved by the FDA as a drug, as a medicine, basically. And at that point, the DEA and the FDA working together as are required to under the Federal Controlled Substance Act determine what schedule it ought to be in. And initially was determined in Schedule 2 and ultimately was in Schedule 3. Marijuana, of course, has not been approved by the FDA for anything, but I'll talk a little bit to that issue in a little bit as well. Other comments?
Yeah, basically, as a citizen, Maybelline doesn't make sense to me. You guys are basically taking a compound and making it synthetic and to mimic the organic compound that's already found on a plant that you can get that has not hurt anybody. I don't need to get into the gateway topic or anything. I just believe that you guys need to remove it today. If you guys could, that would be great for the citizens of Minnesota. Maybelline, like I said before, is in Schedule 3. Why is organic cannabis that has not hurt anybody in Schedule 1 in the same classifications as heroin? It doesn't make sense. And it's a plant, but it doesn't make sense to me. You guys have the power to remove it. Please remove it. There's a lot of people hurting. When I first moved here from Arizona, I was in a big situation. I encountered depression and anxiety because of cannabis, because of not having access to cannabis. So this is the first step, in my opinion.
Anybody else like to say anything?
Yeah.
Okay. Please identify yourselves by your last name and the affiliation you might have with the organization. Thank you.
My name is Dan Bocek. My last name is spelled B as in Victor, A-C-E-K. And I'm here as a representative of the citizens of Minnesota.
Okay.
And we're talking about taking the chemical derivatives from a plant, putting them on lower schedules than the plant itself. And you'll argue that no pharmaceutical company will take this one and because there's no profit in it for them, they can't patent it. It's a plant. Where then is tobacco? Where is the coffee bean? Where are these things on the schedule? They're plants. And if you can't remove this plant from Schedule 1, then let's start acting to put tobacco in the appropriate place on the schedule. We're not going to do that. That's just crazy. The plant cannabis sativa doesn't belong on the schedule at all, in my opinion. You'd be doing a partial step to move it down a step or two to Schedule 2 or 3, but I don't think that's your job. I think that's the legislature's job. Your job is just to say it doesn't belong in Schedule 1 and remove it entirely. Now, if you want to interpret that differently, you can look at the laws. Thank you.
Is there anyone else who would like to make some comments?
Hi. Thank you for hearing me. My name is Scott Fuller, B-O-H-L-E-R.
And are you here representing yourself, or are you affiliated with a certain company? Or?
I'm a member of Minnesota Normal, on the board, and I'm a Minnesota citizen.
Is your mic on? Is it everybody on that?
Can you hear me?
Okay, thank
A
you.
little bit
If you
because
get-
of the
yeah.
lack here.
Is this better?
We have fans on.
Okay, thank
Hard
you.
to hear.
I'm a little hard of hearing too, sorry.
Okay, forgive me while I get over my nervousness.
We're all friendly here, don't worry.
I'd like to tell you a story. That's what I came up here to do. I know someone who, in this case, has Crohn's disease. A wonderful person, works hard, is very giving, has a family, a normal Minnesota, has Crohn's disease, terrible sufferer. thing that they'll do, go to the bathroom like we all do and brush their teeth, right? Immediate throw up. Day begins with throwing up. Unless one, maybe 2 puffs of non-toxic cannabis, and my friend can now brush their teeth, begin their day, eat breakfast, keep the food down, calm the stomach so that the diarrhea doesn't flow. Excuse my blatant description there, but this person suffers terribly. A couple of puffs in the morning and they can begin their day as a normal human being. Simply by putting something into their endogenous endocannabinoid system that's designed to respond to this plant, and it balances my friend's body out so that she can live. And she lives in danger. She lives in fear of what might happen if someone sees her. Because this plant is in Schedule 1, and the law relies on that schedule to say, well, we can't have this because it's in Schedule 1. You know, it's like a circular no. It doesn't belong in Schedule 1. It helps people live their lives. You know, someone else who has chronic headaches and frequent migraines. A couple of puffs and the pain goes away. No synthetics, which they don't want in their body. A natural plant is the solution. If someone's a little anxious, little wants to relax, maybe they go home and have a cup of chamomile tea. This is an herb. This is a green plant that it grows out of the ground and it makes flowers. And that's what we drink in our tea. And it's calming. It affects the body. Is it a drug? Well, it affects the body. That's what plants do. If 1 cup isn't enough, still a little bit anxious, how about a little more chamomile tea? It can't hurt you, right? Okay, you got a headache, how much do we give? Efficacy, what's the strength of the plant and all that? You take a puff. If the headache's not gone, 10 minutes, take another puff. What if you take 50 puffs? Well, you might go to sleep and destroy a bag of Cheetos. Big deal. It cannot hurt you. It doesn't belong in Schedule 1. Please allow my friend to wake up and not throw up without fear of the law, which relies on your judgment here today. Like Morris said, please do the right thing.
Excuse me, Scott, can I add something to that? He talks about the comparison to chamomile tea, and that reminded me of something. Early on, you or someone asked about studies relating to the efficacy of smoked cannabis. And there seems to be a big emphasis on that's the difference between Marinol, which you ingest in a pill, and cannabis, which is commonly on the street because of its high price due to the illegal black market, is commonly smoked. But I want to point out that for one thing, that's an advantage. That's one of the biggest disadvantages of Marinol is the folks with nausea can't take down the pill. So the smoking part is actually an advantage. But I also want to clarify, it doesn't need to be smoked. That's just one method of ingestion. We're talking about removing a plant from a schedule, not whether or not smoking it is the most effective way. It's very commonly made into tinctures, into edibles. These are things that are consumed in the same way as the Marinol pill. And another excellent way to consume it is a vaporizer, which doesn't actually produce any smoke. And were it not cost prohibitive due to prohibition, people would adopt these methods as being far preferable to smoke. So I really want to clarify, we're not talking about smoke as in tobacco and those things. We're talking about the plant, whether you put it in a tea or bake baked goods out of it or consume it in a smokeless vaporizer. Thank you.
It's actually a good point, Anthony, and I should probably not have used the word smoke.
Thank you.
But the gist of that question was really to get at, were there double-blind, placebo-controlled studies of natural marijuana, the plant itself? However, if it is administered, if you will, if you're going to consider it a medicine, whether it's in a tincture or smoke, or put it in the brownies, or however it's done, are there double-blind controlled studies?
We can-
I defer that to Randy's list of studies.
But it's been regulated, so how can anybody getting their hands on it to do a study? No. It's kind of like a catch-22.
Well,
Minnesota-
Minnesota actually has a law that looks.
We allow studies in Minnesota.
And there's a lot of studies. But I just have my final words for you. I just want to, I realize that this board has not had the opportunity to study the efficacy and so on, but I do just hope that you realize in the background that, there's been presidential commissions, going back to the LaGuardia Commission, the Schaefer Commission. Everybody that studied marijuana says it doesn't hurt. I mean, the penalties are greater than, it's a safe drug. It's non-toxic. You can't overdose on it. So that's just on the legality side. And I realize that it's a contentious issue, but it is starting to happen in the U.S. that it's changing. And it's the same way alcohol prohibition changed. It changed state by state. It was the states that got rid of it before the federal government came along. We have 15 states in the District of Columbia that recognize the medicinal value of cannabis. I wish Minnesota would be on the forefront instead of the back end. Thanks.
There was somebody else, I'm sorry, raised your hand. Did you want to come up and make some comments?
Yes, I would like
Step
to.
up to the mic.
Thank you. Good afternoon. My name is Nathan. Family name is Stevens. And good afternoon.
Please spell it if you could, just because sometimes
Sure.
there are variations.
Stevens.
Okay, thank you.
And good afternoon, ladies and gentlemen of the board. I just want to make several comments in regards to the whole discussion at hand. We're talking about law. We've also brought up science. I just wanted to appeal to each and every one of you as human beings, as living flesh and blood men and women, also recognizing that you are a board serving a public utility, that ultimately I do believe you serve the people of the state of Minnesota. Is that correct? And I do believe that you've taken an oath in order to serve the people of Minnesota. Is that correct? There's no sworn oath.
However, the board members can all attest to this from, the minute they're appointed by the governor, and they meet
His oath as a pharmacist.
and they meet me for the first time. The introduction to the board, the orientation to the board, I always start out with, we are here to protect the public. That's what our mission statement is. We're not here to protect the profession. We're here to protect the public. So there's no sworn oath, but we certainly know what we're here to do, and we need to protect the public, of course.
Thank you for that clarification. And also, as Melissa did point out, I'm also addressing each and every one of you as pharmacists, and I do believe that you did swear an oath, as you just stated, to protect and serve as healers.
We have a public member here as well. So
Okay.
No drug training.
Okay, thank you. Thank you. So I want, my reason in clarifying that just introduction greeting to you is I'm speaking to you first and foremost as individual living men and women, not as a board, this amorphous unit, but just to appeal to each and every one of your hearts and souls. To respond to what I would like to say is that I've mentioned many times, I've been here for most of the meeting today, and I've heard many times spoken of the board's care for the public, and I acknowledge that. I thank you for continuing to, in each case that you have heard today, in each matter that you've spoken, to make it very clear that that is your prime motivation. In regards to this petition, there's been many questions I've heard from several members of the board here in regards to studies on cannabis. I would like to just add on the public record here that from my personal research of over 15 years into this matter, I have not found another single drug on the planet that actually has been studied more thoroughly across continents, across states, across multidisciplinary associations And I would encourage each and every one of you as living people with intelligence and care for the public to research on your own time. Even a couple hours of research into this matter would show you that this plant that we're speaking of, this drug plant that we're speaking of, is factually the most studied plant on the planet, the most studied drug on the planet. And so that would I would issue that as a challenge to avail yourselves of that information. I would refer, one source that's a great source that I found phenomenal information is pubmed.gov. I'm sure that you're familiar with that database. That's the government's database of public peer-reviewed scientific journals. There are hundreds, if not thousands, of research documents in regards to cannabis on pubmed.gov. I will not sit here and list my knowledge of hundreds and hundreds of these case studies, but they are there. Just know my words. This plant, this drug, has been studied for its medical efficacy ad nauseum. Okay? I'd also like to share a personal story of my experience with two different friends of mine. Because this is a personal issue. This comes down to human beings caring for and taking care of other human beings. One other fact or challenge that I would like to issue the board is the fact that I'm aware of from my personal research is that over the recorded human history, we do not have a record of a single death caused by this drug. And so I would issue that as a personal challenge, and also to put that on the record as a statement of fact, that I have not been able to discover in my research or to uncover any recorded medical death, not one. In regards to the thousands and thousands of other drugs that members of your profession work with, I don't think that can be said of even one of those drugs. Not even over-the-counter drugs such as Tylenol or acetaminophen. Those drugs are known to cause a number of several hundred deaths a year just by over-the-counter medications. We're talking about a drug here today, tetrahydrocannabinol. THC is the active drug within the plant cannabis that we're referring to. And I would just like to reiterate that there is not, in my research of over 15 years, that there has not been one publicly recorded death attributed to this drug. That's an astounding fact, especially in a country where statistics have shown me that over 250,000 Americans every year die from misdiagnosed or overprescribed prescription pharmaceutical medications. Okay, so those are things that I'm appealing to you each as pharmacists, but ultimately as human beings who are caregivers to other human beings. I have two friends. One friend was diagnosed with cancer 2 years ago. He promptly moved to Colorado to seek treatment through medical cannabis. He just moved back 2 weeks ago in full remission, looking much healthier and of greater higher spirits than I remember when he left. Because when he left, he could barely move. His group of friends had to help him carry bags of clothes. I could go on and on about his emaciated state at that point. But after 2 years of treatment with medical cannabis through ingestion, through vaporization, as a legal patient in Colorado, along with vitamin and dietary treatment, he is in full remission. I have another friend, a fellow Minnesotan. This friend was also diagnosed with cancer about 2 years ago. This person chose the route of chemotherapy, radiation, and pharmaceutical treatment. Over these last 2 years, my friend who's chosen chemotherapy, radiation, and pharmaceutical treatment for his cancer, he is, I guess for lack of better words, wasting away. He's not doing very well, and he
continues to be on the maximum doses prescribed of heavy-duty painkillers such as morphine, oxycodone. These drugs I've seen have caused in him a lot of mental deterioration, a lot of physical immobility, and multiple other side effects. And I need to add that the multiple side effects of my friend who's chosen radiation, chemotherapy, and pharmaceutical treatment, of those multiple side effects, they have been very much alleviated by his illegal use of cannabis. But I just want to contrast those two stories. As my one friend that moved to a state where he was able to be legally, medically treated with a medically viable drug and is now in full remission with his cancer. Now there are, and as opposed to the other friend who chose the traditional route of chemotherapy, radiation treatment, and pharmaceutical treatment, who we're praying for every day. But in all reality, we don't think he probably has long to go. So these are two different stories that I would like to submit here, and I thank you. But there are thousands and thousands and thousands of other cases, and I've talked to people all across the country and all across the world in my years of research who have either legally or illegally used this drug that we're referring to today to no negative side effects. I think that it is a matter of human rights that we're discussing today. I think it's a matter of ultimate importance. And I just want to urge the board, I want to urge each and every one of you as caregivers, as healers, as professionals, also as human beings, to even put maybe an hour into your own personal research with an open mind into the history, into the legislation, because we could form a committee. There's a committee here, right here, of public people who showed up to address this issue, and we could carry on for weeks, and we could share with you our experimentation, our research, we could sit here with a computer and Google, and we could cite double-blind, case peer-reviewed studies. So I don't have a stack of paper with me, but I just want to avail you to the information and the knowledge that anyone with a computer and Google can access pubmed.gov and type in cannabis and come up with a whole long list of studies that have been entered into the published peer-reviewed journals. So, I don't want to, I do not mean in any way, shape, or form to come across as belittling or downplaying, but I also want to state the very obvious fact that now as I speak to a group of professionals, it's very easy to find that information in a number of minutes. So in conclusion, I would just like to ask you each as individual human beings, as caregivers, and as fellow Minnesotans, to really put some serious effort into this personally, professionally, medically, and politically, and scientifically, because the science is out. The science has been there. The science has been there for over 40,000 years of human usage of this drug, and there is not one recorded death. And the benefits go on and 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 on. And I feel that cannabis criminalization is one of the great crimes of the 20th century. Please research the history of the politics and the big money and the big business interests behind the original criminalization of this. I'd also like to state on public record that you can research and find the founding fathers of this country, sovereign freemen, who came here to establish a free country where users, growers, cultivators, and champions of the hemp plant, and also smoke cannabis marijuana. I would like to also just encourage each and every one of you to acquire for yourself a copy of a book by an author named Jack Herer called The Emperor Wears No Clothes. In this book, Jack Herer has gone through Encyclopedia Britannica, dictionaries,
U.S. government papers, and he uses all publicly available knowledge, and he lays out the history of the medical, scientific, political, and historic story behind the efficacy and the benefits of the plant cannabis. Thank you for your time today.
Thank you.
I'd like to say one more thing. In 1986, Judge Francis L. Young called cannabis the safest therapeutically active substance known to man. There's also, I did want to mention the history. I would have liked to have brought in a visual aid, but I have an 80-year-old bottle of cannabis tincture produced by Park Davis. And in the 1930s, at the hearings at the federal level, the drug companies were the ones testifying against it. They didn't know that they were outlawing cannabis because they switched the name and called it marijuana when Henry Anslinger was testifying and wrote the bill.
America's
They
Hitler.
changed the name. So that's really the first time we heard this word marijuana used. Prior to that, it was produced by Park Davis in tinctures. That's history of it is that the medical profession was opposed to it in the first place. I think it's time to go back.
Well, thank you all very much for your testimony and your thoughts and your consideration today for us to think about. In the interest of time, we're going to move forward now. If Dr. Weiberg has some statements he'd like to make, or and then after he does so, some board members would like to comment. Thank you.
And, you know, the meeting's running a little bit longer than it normally does, but I think it is important to address some of these points. So I'm going to take a little bit of time here. I just first want to state, just for myself, I can't speak for the board or respondents, but the previous meeting that talked about taking the time to study this. I have. I actually, as most of you or all of you know, kind of underwent what I call my late midlife crisis and went back to graduate school several years back. It was a master's program specifically that dealt with public policy around pharmaceuticals and drugs. And I actually spent an entire course studying the regulation of controlled substances in the country. It's Harry Anson, by the way, not Henry.
I'm sorry.
And I'm very well aware of the history of marijuana regulation in the country. I'm not going to share them now. I have my own personal opinions. I don't think it's appropriate for me to share my personal opinions about what I think ought to be done with the regulation of marijuana in this country and this state. Because I'm here as the executive director of the Board of Pharmacy, and what my job is to do is to look objectively at the facts, both the legal facts of the situation. At this point, as I mentioned first, I think that's the first thing that the board needs to look at because of the specific nature of this petition, which is to engage in the rulemaking process. If we were to engage in the rulemaking process, that would be the stage at which I think some of this research I've already done. I'd have to go back to that research. I'd have to look it up again. I'd have to prepare some analysis documents for the boards at that point. But the first thing we have to look at are the legal questions in the case. And so what I'd like to do is I've got Mr. Hanna's memorandum up on the board, and I just want to make a couple of points here to some of the points that he's made, or a couple of responses to some of the points that he's made, and then go back to the staff analysis document, the staff analysis recommendation document. So this is page 2. It's the second paragraph. Take a look at the second sentence. It says, first, removing marijuana from Schedule 1 as petitioned herein will not result in the immediate or even guaranteed access to medical marijuana by medical patients in Minnesota. That is correct, but it doesn't go far enough. In fact, even if the board were to remove marijuana from Schedule 1, and many people have said that the board ought to do that, even if the board were to remove marijuana from Schedule 1, nobody would be able to have legal access to marijuana in Minnesota because the criminal penalties would remain in place.
That's right.
The board has absolutely no authority to change in criminal penalties. Now,
Kurt.
I'll go back to why that's important in a little bit. It would still be a crime to possess and sell marijuana. Down at the bottom of this page, this actually is a follow-up on what I just said. The very last sentence says, by working with the existing Controlled Substance Act structure and procedures for removing or reclassifying drugs from Schedule 1, the careful exploration of marijuana as a medical alternative could avoid the passage of independent medical marijuana access laws that may result in inconsistent laws in Minnesota. I would argue that is not true. You would still need the passage of a medical marijuana law in order for marijuana to be used for medical purposes. Having the board remove marijuana from Schedule 1, as I just mentioned, would not allow for the careful exploration of marijuana as a medical alternative if that sentence means people could use it. If the sentence means that removing it from Schedule 1 would generate potential discussion, the board doesn't need to engage in the rulemaking process to generate discussion about this issue. This issue is already being discussed here today. And so I guess I do not agree with that statement. On the next page, I just point out, it talks about at the top here, it's a matter of record that a growing number of state governments have recognized that marijuana has substantial value to medicinal applications by enacting laws and regulations authorizing such use. I just want to point that out. And then go on to the second page because this is kind of related. It says in this paragraph that starts near the top there, given the substantial body of states recently authorizing marijuana for supervised medical treatments, it is simply implausible to suggest that there is no accepted medical use for marijuana in the United States, or that no safety control conditions have been determined for such use, as evidenced by medical marijuana regulatory dispensary programs that are developed in such states. I would argue that one of the things that this board would need to do if it got to the point where it was considering engaging in the rulemaking process to remove marijuana from Medical 1 is, since the legislature has not defined what the term accepted medical use in the United States means, this board would have to consider exactly what that means. One of the things I just want to point out is in doing some research, interestingly enough, I was looking at an Iowa organization, I don't remember its name, but I think it's the organization that prompted the Iowa Board of Pharmacy's action. They mentioned a federal lawsuit that I'm sure some of you who will follow this are going to be aware of. It's Princeton versus DEA. And the question of what accepted medical use under the federal statutes came up. And it is true that in that case, under federal law that applies to the administrator of the DEA, the judge in that case basically disallowed some of the arguments that the DEA administrator made. One of the arguments that the DEA administrator tried to make that was disallowed by that judge as a matter of federal law was that the administrator tried to say that because the commissioners that drafted the Uniform Controlled Substance Act, that the states all use, or at least most of the states, including Minnesota, use as the basis of state controlled substance acts, because the administrator tried to say because those commissioners defined accepted medical use in their notes as FDA approval, therefore it was okay for the DEA to assume that accepted medical use was FDA approval. The judge in that case said that the DEA administrator could not do that because those commissioners had not even yet released that document when the Federal Controlled Substance Act was written. However, we are trying to interpret state law, and in fact, the State Controlled Substance Act is modeled on the Uniform Controlled Substance Act. I'm not saying that the board's going to make this argument, but one of the arguments the board might potentially make when it's trying to determine what the legislature meant by accepted medical use in the United States, knowing that the legislatures would have had access to those documents and would have seen that the commissioners defined accepted medical use as being approved by the FDA. And even if the board doesn't make that argument, believe me, if the board were to engage in the rulemaking process, we have no authority to do expedited rulemaking in this area. That I can guarantee you that there would be a request for a rules hearing for an administrative law judge, because as passionately as you all feel about this issue on your side of it, there are people who feel equally passionately on the other side. And I have no doubt that there would end up being a hearing before the administrative law judge. And I have no doubt that someone will make the argument that accepted medical use means FDA approval. It's one thing to consider. Although that's not the key thing. I just wanted to point that out. So even though I know that petitioners believe strongly that because other states have passed medical marijuana laws, that the Minnesota board is going to have to include necessarily that there's accepted medical use, I think it's more complicated than that. I think you have to do a lot of research, both legal and scientific, for the board to potentially say that there was, in fact, accepted medical use. The exhibits that the petitioner mentions where the principal psychoactive substance of cannabis sativa was transferred to Schedule 2, and then there's another reference to transfer to Schedule 3. And again, these are FDA-approved products we're talking about. This is Bernabinol, this is Veronal. And it's a little bit different to say that a drug that's gone through the approval process required in the Food, Drug, and Cosmetic Act is necessarily means that, and this is why I asked the question about controlled scientific research, you can't rely on the fact, I don't think the board can rely solely on the fact that the FDA approved Bernabinol in this particular schedule, say that marijuana itself, whether it's smoked or used in a tincture or whatever, is safe and effective for anything, just based on those actions. I want to point out that just in this summary memorandum, the petitioner includes one portion of the American Medical Association document and says that the AMA recommends marijuana be removed from Schedule 1. In the exhibits, the full document is there, and in fact, in reading that, the AMA does not recommend that marijuana just be removed even from federal Schedule 1 entirely. What it talks about under the recommendation portion is it says, RMA urges that marijuana's status as a federal Schedule 1 controlled substance be reviewed with the goal of facilitating the conduct of clinical research and development in cannabinoid-based medicines and alternate delivery methods. This should not be viewed as an endorsement of state-based medical cannabis programs, the legalization of marijuana, or that scientific evidence on therapeutic use of cannabis meets the current standards for prescription drug product. So it's a little bit different than is portrayed in this particular document. Then maybe I should just briefly mention the fact that, and those of you who went to the NABP annual meeting, which occurs now, that the Iowa board received the Fred T. Happy Award for actually two reasons. One was for tracking down on internet pharmacy websites. The other was for their work in medical cannabis. But I'm just going to mention it. You all said the fact that some other board might have received an award has no bearing on the discussion before this board. We're not in this for awards. The bottom of page you know,